Yeah, so there's a federal law that deals with the protection for active duty military and their dependents, that be their spouses or children that are dependent on that military personnel that are, again, on active duty. This is not affecting retired military. This is not someone that is on a National Guard that has not been called up for active duty. So there's very particular guardrails as to who is covered under the Service Member Civil Relief Act for active duty status. The first thing to do is in the rental agreement, you're asking the question whether the tenant is active duty or its spouse or dependents in the lease. And that would be your first sort of red flag that if they go into default, you know that they're active duty, so you stop the sale process based upon the contractual notification. If they did not notify you that they're active duty, but you start going through the default and lien process, and you are then notified that someone is active duty service military, you would stop the lien sale as well and investigate. Now, how do you investigate? So Melissa's right. There is a public DoD website that's you can available. I'm sure Tommy can put it out on the screen, and I can provide it, where you can check with the tenant's information if they're active duty military. And if you want to go deeper into the investigation, there are paid services where they'll provide an affidavit of verification of research as to the tenant's active duty status. And if something is found, you have to stop the sale until you get a court order for approval to sell. And this is really where the settlement issue comes in. I mean, goodness gracious, if they're active duty military, they've fallen behind, and you can settle out the account without having to deal with a court action to sell a tenant's goods, please do that for active duty. That would be the best solution that I can think of. Otherwise, there may be folks that, because of their active duty status, hide behind it and intentionally not pay you and make you go through the steps of court order to enforce your lien rights. So that's what you do. You have to go through the courts to get the court order to approval for the lien sale. There's also, look, and many of you have very active solutions to these issues, contacting base commanders and talking to them about their service members that are assigned to that base and their default of the rent payments. We get a lot of support from the JAG Corps of certain bases to work with us to settle out accounts to avoid a lien sale. But bottom line, Melissa, your question about SCRA, the support weighs in that tenant's favor because of their defense of our country. Treat them accordingly and protect them as well. But if they take advantage of the law, then you have the right. You have a remedy of solution through the courts. In fact, I'll just say this generally, because there are these little obstacles along the way in many self-storage relationships with the tenants, where tenants will bring up court defenses, domestic defenses, bankruptcy defenses, active duty defenses, and you find yourself battling through a tenant's defense. Don't give up. You have legal rights. Mm-hmm. You may want to wait. May want to see how it works itself out, but don't ever feel as if you have no remedy. I can promise you the court systems are frustrating, but there is a remedy to be had through the courts in these sort of situations where you're providing a service to your customers to use your space for the storage of their property. They should pay you. And if they don't pay you, you do have a remedy.